First of all, thank you all so much, faculty, students, local attorneys, others, friends, for coming today to be part of day 2 of our conference short titled Order with or Without Law. It is a real pleasure for me and the College of Law to be able to bring these events to you. It's really courtesy of the Chapman Trust, made available through our Chapman Professorship, which I currently hold. And I want to thank the Chapman Trust and Greg Gray and Sharon Bell for making events like these possible. I also want to thank all the folks who have worked wonderfully with me and independently to nail down all of the great events we're doing to make sure that our guests are accommodated. I especially want to thank Barbette Veet and Gina Bradley, but there are others as well who have been such great colleagues and collaborators in making Order with or Without Law possible. Yesterday we had terrific events. We had a panel that started things off. We had a keynote address at 5:30 by Bob Ellickson, and we learned about a wide range of fascinating things, including membership associations and how they function as a sort of strange intermediate between formal law and informal rules or norms, which is the sort of the focus of this conference hovers towards informal norms. But Bob reminded us last night that that's not the whole story at all. I just want to remind anyone who may not know this that we not only have today's dual keynote address, but we also have at 2 p.m. or is it 2:15 p.m. Today, 2 p.m. We have a panel which will shift towards literature and the law. We will have 2 English professors and myself speaking essentially about 19th and early 20th century publishing norms in the United States, modes of distribution, mass audiences, and essentially how law became a background rather than a foreground factor in the publishing, particularly of foreign works in the United States. That'll be fun for me, certainly, and the panelists, we hope you're there for it too. I want to introduce our dual keynote speakers today, Cal Raustiala and Chris Sprigman. Cal is currently has a joint appointment between UCLA Law School and UCLA International Institute, and since 2012, he's served as UCLA's Associate Vice Provost for International Studies, and for some time now as Director of the UCLA Burkle Center for International Relations. Chris Sprigman, just formerly of University of Virginia Law School, is now with NYU Law, just as of last year, which means that an already terrifically strong intellectual property group of law professors at NYU Law just got significantly stronger. In fact, we had just 2 or 3 weeks ago one of his colleagues, Barton Beebe, here to give us a fascinating talk, lunch colloquy talk, and we now have his colleague Chris Sprigman as well. I could talk endlessly about their articles, their contributions that seem to pour out every year, sometimes singly, sometimes together, sometimes with others. They're a great example of co-authorship. There's a great deal of this they do, and they do it so well. But I just want to mention and plug their fairly recent book with Oxford University Press, I believe 2012, called The Knockoff Economy. Their articles had been an inspiration to me as they came out over the last 6-7 years, and then a lot of this work was gathered and amplified and enriched in their book Knockoff Economy, which essentially tells a story about how intellectual property rights are not always and everywhere necessary for spurring innovation. The typical story is, without intellectual property rights, there will be no intellectual property. That is a tale that they challenge, and they challenge it, I think, very richly, very interestingly. They will carry on that that quest and that exploration today in their talk about adult entertainment. So let me turn it over now to Cal and Chris. Thank you.
All right, thank you, Bob. So we're going to do this as kind of a tag team effort. Before we get started, I really want to thank Bob for organizing this conference, which has been super interesting for us. I want to thank Dean Janet Levitt for hosting us here, and Barbette and Gina for all the organization. It's been great. A super interesting conference on order with or without law, and we're going to continue that theme in our talk. The way we're going to do it is I'm going to kind of set the stage, hand it over to Chris. He's going to talk a little more about one particular example, which will explain some of the framework that we're going to use, which is comedy, and show a couple of clips. Then we're going to talk about adult entertainment as another example, and then, which I'll do, and then we'll hand it back again to Chris to conclude and kind of wrap everything up, put a nice bow on it. So when I tap Chris on the shoulder like that, he's up, and we're going to go back and forth. That's how it's going to work. So, okay. So what we're going to do today...
Didn't you want the screen?
I don't need a screen yet. Thank you. The screen will come later. Yeah, when he's up. I'm like you. I don't do PowerPoint. So, so what we're going to do is
the president.
Yeah, the president. Okay, fair enough. We're going to talk about innovation and IP as an example of order without law. And what we're going to do is talk about what has been referred to a couple of times so far in the conference, which is this idea of negative space of IP, or what is the negative space of IP. So what we mean by that, if you weren't here yesterday when it was first raised, is that for most of us who think about intellectual property, we think about what is encompassed by intellectual property first and foremost. We think about books, we think about films, we think about music, conventional creative fields like that. But there is this negative space, which means to us all of the creative work that's out there that does not fall under copyright, patent, trademark, etc. One good example, I'll talk about in a second, is the fashion industry. This was mentioned yesterday. Comedy's another. There are many creative domains. Chris Buckfusco talked about chefs and recipes yesterday. All of these are creative fields, without a doubt, but they either do not fully enjoy IP protection or they only enjoy it in a partial sense. And so that's the idea of the negative space of IP. And in many ways, this is an extension of the great work that Bob Ellickson really pioneered and has continued in thinking about how order can develop without law. So in these cases, there's creative order that develops, but there is not a legal framework, an IP legal framework, under which it operates. So again, I'll talk a little bit about some examples. Chris will talk about comedy. We'll talk about online entertainment, online adult entertainment, all in this guise, and try to give you a big picture about how this all works. So let me just start off with fashion as a good example of what I mean, or really what we mean. This is really what Chris and I first put on in this area. So I think, as many of you know, the fashion industry is rife with knockoffs. And knockoffs are everywhere. It's a part of the ecosystem in fashion. If you go, I looked, and there's a Forever 21 here at the Woodland Hills Mall. Some of you may have been there. That is a company that's entire business model is based on knockoffs. And they're very successful. It's a huge multi-billion-dollar company. So there's nothing unusual about knocking off. Just as kind of an empirical matter, that's how the industry operates. What's interesting for lawyers is, how does that rampant knocking off not drive down the level of creativity and creative production in this industry? Why does it not destroy the industry? Because, of course, the basis for intellectual property protection in this country is that, but for that protection, creators will not create. That is why we have it. And if you go to Congress, that's the sort of story you'll always hear. If you look in the Constitution, that's the reason given by the framers. That's been the reason throughout American history for IP protection, is to incentivize creative work. So here's this really big industry, and I don't want to just single out Forever 21, it's across the board, that operates incredibly well without having copyright protection for its designs. Now, as an aside, they do use trademark very strongly. Brands are incredibly significant. So I don't want to say it's not about IP, but designs can be copied freely. So what we found in looking at this industry was that the freedom to copy not only did not destroy the creative impulse in the industry, it actually incentivized it and accelerated it. And we call that the Piracy Paradox. And what we meant by that was that as designers came up with a new design. Those designs were then adopted by others if popular. What came out of that was something that's familiar to all of us, which is the idea of a trend. So trends are the centerpiece of the fashion world. And what is a trend but a series of things that look alike? That's what makes it a trend. Sort of looks alike, maybe not identical, but very close. And so this ability to copy and to create a trend is really what has fed the fashion industry. We all know that things come into fashion and they go out of fashion. And so what this does is accelerate that process. And it provides a way for consumers who care about fashion to say, hey, I want that look or I want that item. In other words, it anchors their expectations about what is in style at a given moment. So what we found is that paradoxically, the freedom to copy was a good thing for this industry and really kept it moving and kept the creative juices flowing ever faster. So that spurred us to think more about how this kind of economic success and ordering could develop despite the lack of IP protection. And so one way to think about it is that this negative space that we talked about, or I talked about a moment ago, turns out to be pretty positive from an economic point of view, at least in some industries. So the fact that IP protections don't exist for designs doesn't destroy the ability to make designs or the incentive to make designs. It actually spurs it more. That is itself an interesting finding, but we think also a pretty powerful statement about our IP system, because it gets at this very core idea that but for IP protection, you will not see creative work. So that is a thread or a through line in everything we're going to talk about today and everything that we've worked on in this field. So just to give you an example of other works, there are many other people who have worked in this vein. Really interesting work on magic tricks. Chris talked about chefs and their recipes. I'm guessing there might be a roller derby fan here, maybe not. There are these really amazing systems of deciding what kind of name you get if you're a roller derby player. Tattoos, haircuts, furniture design, et cetera, et cetera. Lots of interesting fields and lots of interesting work that's been done, all in the same family of thinking about what happens to creative work outside of the conventional IP structure that we tend to think about. So, so that's kind of the biggest point I want to set the stage for, and then I'm going to step off in a second. The other thing I want to mention is that, and this is important as well, just because there is not IP protection in a given area, like let's say fashion design, it's not just about do we have a lot of creativity in that situation or do we see almost no creativity. It's also what kind of creativity. So in other words, the legal rules not only affect the quantity of innovation that happens in an area, they also can affect the type of innovations. You might get certain kinds of creative work versus other kinds, depending on whether you have a lot of IP protection, a little bit, or none. So we'll talk about that a bit more. Last and final point before I hand it off to Chris. Bob, yesterday in his keynote, mentioned legal centralism, and I think a lot of us have talked about that, the idea that law is what matters. And we're all lawyers here, and so we're lawyers because we think the law is important. And so the other, I think, interesting thing to come out of this line of research is to question that assumption. Does law really matter in all of these cases? Or if it does, why and when does it matter? How much does it matter? And what we found is it often matters a lot less than we think. So that's important for us to know as lawyers, and I think that's one of the reasons why lawyers in the past, or certainly legal academics like us, tended to ignore some of these areas like fashion. So until maybe 10 years ago, there was hardly anything written about it. Nobody really looked at it. And I think they didn't look at it because they said, well, hey, the copyright statute says doesn't apply. It's never applied in the fashion industry in the United States. So why bother? But we think it's really fruitful to look at those areas. And so in a sense, all of this work questions some of the assumptions about legal centralism that have come up again and again at this conference. So with that in mind, let me turn it over to Chris, who will tell us a little bit about comedy, and then, as I said, I'll step back in a moment.
So now we'll put something up on the screen. We'll see if it actually works. It's possible, I suppose. Maybe not. There we go. Okay, so I'm Chris Sprigman. I'm going to pick up where Cal left off. So like Cal, I want to acknowledge a debt that we owe to Bob Ellickson and the order without law scholarship. What I'm going to talk about represents a movement of this scholarship into the study of innovation. I don't say into the study of intellectual property, I say into the study of innovation for reasons I'll explain in a moment. So I want to start out talking about, not about comedy, but just for a moment about these two slides. So on the left, or on your left, you see a slide from Microsoft's Encarta. And on the right, you see a chunk of a slide from a page from Wikipedia. So go back to 1995, if you can, in your mind. And there are two things happening. So in Redmond, Washington, Microsoft, which is at the time either the biggest or the second biggest corporation in the world, depending on what month, by market capitalization, depending on what month you're talking about, Microsoft had a whole bunch of cash from selling their early versions of Windows, as well as MS-DOS, their operating system. And they wanted to invest this cash to provide what they thought was a tremendous public benefit, which it almost surely was. They were going to design the world's greatest online encyclopedia. So they set aside a whole bunch of money, millions and millions of dollars that they dedicated to this, and they went around hiring a bunch of cartographers and encyclopedia specialists and subject matter specialists and business people and product development people, and they got a team together, and this team, over the course of the next few years, produced this product that they called Encarta. So the way that they distributed Encarta at first, they charged for Encarta CD-ROMs like you would charge for paper encyclopedias, and then eventually they moved it onto the web, and they basically first charged for access and then had it be ad-supported on the web. Okay, so millions and millions of dollars of investment by one then and still one of the most successful companies in the world, dedicated to providing an online encyclopedia. All the content on this encyclopedia would be protected by copyright. The idea was that they would use their copyright to exclude copyists, and they would make money off of this encyclopedia one way or the other. So this was their business strategy. At about the same time, a group of people getting together really around the world who seemed kind of flaky and even vaguely communist came up with this idea for Wikipedia. So what they wanted to do was they wanted to work together without any really formal rules. They had a set of norms, right? A norm of fairness, a norm of neutrality, and a norm of collective editing, right? They would edit each other's work, and they had this technological platform, the wiki, on which they would accomplish this. They decided that they would offer their work to the public under something called a Creative Commons license, which essentially meant that you could take this content, you, me, any of us in this room could take this content, we could copy it, we could modify it, we could redistribute it. All we had to do was we had to credit Wikipedia, right? So it's not copyright, it's something much less restrictive than the default rules of copyright. So you have this experiment, you have this competition between the copyright business model and the non-copyright business model to produce something which requires massive investment. I mean, truly massive investment, sustained investment by lots of people who have to be coordinated over time. And you all know how the story ended, right? Wikipedia became the greatest reference tool the world has ever known, greater by far than the Encyclopedia Britannica, both in terms of numbers of entries and in terms of influence. It's the only thing that people under 30 seem to know exists as a reference tool, for better or worse. It is also the only place really where you find evidence today of Encarta, which is in the Wikipedia entry for Encarta, which I produced up there. Okay, so that's the story. Now, this is a good case of intellectual production without intellectual property, or the negative space of IP, right? This is not an IP-driven business model. This is a business model that aims very purposefully at negating the restrictions of IP, and this has been just a small example of something we have seen over the last quarter century grow into a tremendous behemoth, a behemoth dominated by Americans, and that is open source software, which is important all around the world, and especially here in America, and this is an enormously creative, fertile field which proceeds without much resort to IP. Now, Cal and I look at stories like this, and what we see is we see a lot of order without law, we see a lot of IP's negative space, and as Cal said, this represents the kind of pushback against legal centralism that Bob Ellickson and the Order Without Law Scholarship so expertly brought to our attention. We see here just a small example of something we see in a lot of fields. So let me talk a little bit about comedy. And the way I'm going to talk about comedy is I'm going to show you a couple of clips. First clip is a guy named Henny Youngman, who unfortunately passed away. To my mind, he's one of the great comedians in American history. He's what you would think of as a post-vaudeville one-liner Toomler, a kind of Catskills style comedian. The second is a much more modern comedian. Her name is Sarah Silverman. You may be familiar with her. If you are sensitive to bad taste, flee the room. So first I will show you Okay, the great Henny Youngman. So, what is Henny Youngman doing? Henny Youngman is telling jokes, right? These jokes range over a whole bunch of topics. They're not really tied together. He's a wonderful guy. He has this kind of persona, but he's really a joke slinger. He is representative of the way comedians used to be. So in the 40s and the 50s and the early 60s, this is how most comedians were. So I spent a really pleasurable couple of days in the Smithsonian Institution in Washington, D.C., looking through the joke files of Phyllis Diller, who was a female version of Henny Youngman, hilariously funny. She had over 50,000 jokes on index cards in her file, okay? And this is what comedians of this era did. They selected and arranged jokes. They had large databases of jokes. They thought about their audience. They thought about current events, and they basically laid out a selection and arrangement of jokes and slung them at the audience. And it would go on like this for an hour, okay? So this is stand-up comedy at a certain period of time. Let me show you a woman, Sarah Silverman, who's quite representative of stand-up comedy as it exists now. And what I want to discuss after you're done watching her are the differences. And don't blame me for what you're about to see. This is all in service of scholarship. Okay, I think it's safe to say that Sarah Silverman and Henny Youngman are very different. And this difference is not just random, this difference is actually characteristic of a difference in stand-up comedy. So Henny Youngman is telling jokes, Sarah Silverman is playing a character, right? She's playing a pretty young monster, right? Who has a certain sensibility and who is unspooling a narrative. This narrative is linked, very densely linked, to the personality that she develops on stage and that she maintains, right? What Henny Youngman and Sarah Silverman have in common is that they exist within a community, right? A community of comedians. So let me tell you a little bit about the community of comedians when Henny Youngman was a comedian. You stole anything you could steal, right? So comedians had no norms back in the day against stealing jokes. In fact, they ran something that they called the corn exchange, which was the recognition that jokes were essentially public property. We bought them, we sold them, we stole them, right? We adapted them. This was part of a commons, essentially, that comedians could access. Milton Berle had a great joke. He would come up on stage and he would say, you know, the guy who came on before me was so funny, I dropped my pad and pencil, right? So this was a norm at the time of open access to other people's jokes. You know, it wasn't the smoothest. Community people did sometimes sling insults, right? So people called Milton Berle the thief of bad gags. Bob Hope was accused of stealing jokes. A lot of comedians of the day were accused of stealing jokes, and some of them actually cheerfully admitted to it. It was a practice, a regular practice. There were no lawsuits among comedians for stealing jokes. Okay, move forward, right, to the late 1960s, comedy changes. So you have a generation of comedians, Lenny Bruce, Mort Saul, people like that, who become much more politicized, much more personalized. They take comedy in the direction in the 60s that so much of popular culture was going in, more individualized. And comedy becomes less of an enterprise of collecting and slinging jokes at people and more of an enterprise of kind of self-exploration, individualized narrative, individualized persona, which is what you see reflected in Sarah Silverman. She is the latest development, or one of the latest developments of this style of comedy. Okay, at about the same time that comedy changes in this way, the kind of nature of the art form, the nature of the rules governing joke stealing change. They're not legal rules, because comedians still do not sue one another. If you look for lawsuits between rival comedians, you will not find them. You will occasionally find a comedian suing a t-shirt company or suing a book publisher, someone outside the community, but within the community, no lawsuits. Okay, what's changed? What's changed is that starting in the late 60s and very much strengthening in the 80s and continuing to today, comedians developed a set of social norms about joke stealing. A norm against stealing jokes, norms about how we recognize ownership, and norms about how we recognize transfers of jokes. These norms are backed by a pretty stiff regime of community sanctions. Comedians spend a lot of time in each other's company in comedy clubs around the country. They see each other's materials. They have a sense of the pedigree, where material comes from, and when they detect stealing, they report. They try to work things out. If working out is not in the cards, they retaliate. They retaliate in a few ways. Bad-mouthing is one of them, and as Bob noted yesterday, comedians are excellent at bad-mouthing. Robin Williams, recently departed from us, had a really bad reputation as a joke thief. There's an interview with him in Playboy magazine where he says, you know, at a certain point I stopped going into comedy clubs, I stopped doing stand-up, and I stopped going into comedy clubs. Why is that? Because I couldn't stand the bad-mouthing, I couldn't stand the looks that I got from people. It drove him out of comedy. Not too long ago, Carlos Mencia, a rather famous joke thief, was confronted by a quite angry fellow comedian, a guy named Joe Rogan, in a comedy club in LA. It was videotaped. This videotaped confrontation where Rogan accused him of joke stealing, got up in his face, threat of violence, audience got involved. This went on forever. This went on YouTube and went viral. Carlos Mencia since has been lampooned by the guys on South Park, where he's beaten to death by a cartoon Kanye West for stealing a joke, right? So the repercussions continue for Carlos Mencia. All this is to say that in the comedic community, bad-mouthing combined with group boycotts, that is an agreement by comedians not to work with recalcitrant joke stealers, and the occasional threat or actual carrying out of physical violence against joke stealers restrains joke thievery where law does not enter. Okay, now what do we take from this? Well, the typical dialogue about IP protection is more versus less, right? We have more IP, we get more creativity. We have less IP, we get less creativity. We don't really see any evidence of that here. So a paper that kicked this study off by Dotan Oliar of the University of Virginia and I, we looked at this question. We don't really see any evidence that there was any dearth of comedic production before the norm system took hold in comedy. We see lots of jokes during the stand-up comic era of the Henny Youngman type joke slinger. What we see is not more material when the norms take hold. What we see is different material. Right? We see material that is more personalized, that is more narrative, that is more individually tailored to individual comedians, that represents higher levels of creative investment. Okay. Now, what do we think of this? Right? It's not how much we get, it's what kind of creative output do we get. What do we think of this? Well, it's not a simple question. It's not a simple question of more versus less. It's a question of what kind of culture do we want. Right? In the old comedic community with rules of basically commons or sharing, we got the kinds of jokes that were perhaps not amazingly original, but they were the kind of jokes that you would tell to your friends. They're the kind of jokes you'd tell to your family. If you think of comedy as serving in society the function of a kind of social lubricant, you probably like that kind of comedy, and you probably like the free appropriation regime that goes along with it. If, on the other hand, you think of comedy as serving a role in society of or political statement or individual exploration, the kind of deeply original comedy that we get today, the more individualized, the more diverse. If you think of comedy not as social lubricant but as art form or as political critique, you probably like today's comedy, and you probably like the informal regime of norms, right, anti-stealing norms that accompanies it, right, that grew up alongside it and that helps cement it in place. Right? So this isn't a question about how much, it's a question about what kind. And unlike the question about how much, which is primarily a question about that lawyers and economists talk about, this question about what kind involves all of us, right? This is a democratic question. It's a question that cultural theorists can talk about. It's a question that ordinary people can talk about. Now we see this kind of thing replicated again and again across these areas that we study of the negative space of IP. So I wanted to give just a couple of examples of this. So Bob Spoo's book is an example, his book Without Copyright. So in this book, we see the 19th century American publishing industry operating in a world where foreign works essentially don't get copyright, and they're free to be pirated here in the States. Now the ideology of copyright says, well, there'll be chaos, right? There'll be chaos. There'll be a kind of free-for-all leading to no investment. What we see instead is this quite detailed and fluid system of trade courtesy that leads to American publishers making what look like purely gratuitous payments to foreign publishers and foreign authors, and also among themselves in the US agreeing to a kind of first among pirates rule. And I say that advisedly because these are not pirates, these people are doing what they're doing legally, but unauthorized printers, kind of a first come, first owner principle that rules. Now that's a very crude distillation of Bob's work, which is much more nuanced than that. But the point is there's quite a bit of order without law in the States. I would note that if you're thinking about what you get from that regime, what you probably get from that regime is a lot of literacy spreading in the United States because books are provided relatively inexpensively. There's a recent empirical study about literacy in continental Europe, and it showed during the 19th century that Germany's comparatively lax copyright regime also led to an increase in literacy among Germans of the time. So this is not just of academic interest, this has real life policy implications. Now, to my mind, and I'll depart a little from descriptive just to get a little bit normative, I'm surprised that, so I encountered Bob's work when I was in law school. I'm surprised, kind of annoyed at myself, but also just generally surprised that the IP without IP or the negative space of IP work didn't come earlier. For the following reason. So the story that IP tells about itself is a legal centralist story writ large, right? So without these property rights, creativity will fail. No one will, but a blockhead, Samuel Johnson said, writes but for money. And so if the writer can't get a return on his or her investment, only blockheads will write. And that is the motivating force behind IP. So it's a perfectly sensible theory about how the world works. But like a lot of perfectly sensible theories, when you look at the world, reality just looks a lot more messy and interesting and subtle. It took a long time, I think, for IP lawyers to get to this examination of the world because the theory was so, in a sense, comforting and sensible. They were used to seeing IP laws having a kind of central role in spurring creativity, and they didn't want to look where IP wasn't. They wanted to look at places where IP was. That's a bad mistake, right? That's mistaking the means for the ends. The means are intellectual property. The ends are innovation and creativity. IP lawyers should have been thinking more like innovation lawyers, and they should have been caring more about innovation and less about the tools that we thought were so effective, and that are, in some senses, effective, but in others, not. So with that, I want to talk a little bit, before turning it back to Cal, about some areas that I think remain to be studied, and these are really important. So furniture, right? We have a huge furniture industry here in the States. Without discussion, it has some IP around the edges, it has trademark, it has a little bit of copyright, but the basics of furniture design are only lightly covered by IP. We have a big furniture design industry here. Very different rules in Europe. It would be really interesting to do a cross-Atlantic comparison of the industries here and there to see how these industries work and why we get innovation on both sides of the pond. More to the point, design protection generally, so industrial design, everything from toasters to bicycles to fashion designs to motor scooters to portable generators. In the EU, all of these pieces of industrial design get protected against copying. In the US, very few of them do. For example, fashion designs hardly ever. Toasters, not at all, right? Motor scooters, similarly. Shape of car bodies, not at all, right? So we have an enormous variation in at least the formal law on the two sides of the Atlantic. Someone's got to look, for example, at the American appliance industry and at the European appliance industry and see if they innovate differently, if they run differently. Somebody's got to look at the EU design protection regime in general and see what industry categories actually make use of this. So just a snapshot. When Cal and I did our fashion paper, we spent a lot of time looking through registered designs, way too much time. And as it turns out, very few fashion designs are registered. Very few. Lots of portable generators. So, there was a three-letter acronym that occurred to me. I won't repeat it here, but I started thinking I want to know why this is. So I made some phone calls to some Japanese portable generator companies and asked, we didn't report this in the paper because this came after the paper, but I got on the phone with a lawyer at one of these companies, and he said to me, look, portable generators are a very mature technology. They all basically work the same. They're all basically as good. They cost about the same. They're very competitive one with the other. We need to differentiate our product. So how do we differentiate our product? By making it look different, right? Okay, now, is that progress? Right? IP is supposed to be promoting progress. Is that progress? Well, that's a difficult question. So one account is that because these portable generators look differently, different looking generators are satisfying different preferences, consumer preferences are being satisfied better through product differentiation. That's a story about progress. Here's a story that's not about progress. These are basically commodity items. They would be competing very sharply, and consumers would get the benefit of that competition. What the manufacturers are doing are creating meaningless distinctions using IP. This actually allows them to increase the price, right? They move from sharp textbook competition to kind of market power-based competition or oligopoly competition. This just transfers wealth from consumers to producers. This isn't innovation at all. This isn't progress. Okay, now I don't really have a view on this yet, but that's an important question which someone should delve into. Now, I talked a little bit about some virgin territory. Cal's going to talk about some territory that's definitely not virgin, and that's adult entertainment. So I'll leave you.
All right, and I'm also not going to show any images for obvious reasons. So as Chris said, we've continued to think about this line of work. And one of the areas that we were drawn to, and we considered it actually as a chapter when we wrote the Knockoff Economy, was pornography or adult entertainment, because it is, again, one of these very big industries. I'm just going to bracket and totally put aside the issue of, is it a creative industry? Chris was just alluding to this issue about generators and is that progress? You could say this about a lot of things that we're talking about today. Does it matter that there's 10,000 new designs a month that Forever 21 puts out, or is that just kind of churning through a bunch of variations on a theme that don't really matter? Those are interesting normative questions that I don't feel well equipped to kind of answer. And obviously, all of this goes in spades for adult entertainment. But what we're interested in is, this is a really economically significant industry in the United States and globally. It's huge, and very few people have thought about it from an IP perspective. So we're trying to do that. This is very preliminary, so I'm just going to say a little bit about it as a way to kind of bring this whole discussion home. So first of all, just some basic history as it connects to IP. For most of American history, anything considered obscene or pornographic did not enjoy copyright protection. And really only until the Fifth Circuit in 1979, in the Mitchell Brothers case, said that essentially you enjoyed copyright protection even for pornography. Was it at all clear that pornographic works could avail themselves of copyright, in fact had copyrights? And even today, not every circuit has said the same. And there are cases that fall in different ways. And so there's some unclarity even now across the United States about exactly what kind of copyright protection adult entertainment enjoys. But generally speaking, it enjoys copyright, and has, again, since 1979. So we have many decades of experience with that. That said, much like comedy, the industry doesn't really rely on copyright in any meaningful way. In fact, IP isn't a big part of it. So they mostly operate outside of the IP system. So in that sense, they fit with everything else we're talking about today, a kind of negative space of IP. A couple of other differences to point out about this industry, or features, I guess. If you can compare adult film to conventional film. So I live in Hollywood. Hollywood is a really big industry too, but it's not only big, it's dominated by big players. So Sony Pictures is an $8 billion a year company. There are no such companies in the adult entertainment industry. They're all very small. So if you think about the biggest ones, the most famous Playboy, Vivid, these are minnows compared to any Hollywood studio. Even the most mediocre Hollywood studio that you may never have heard of is orders of magnitude larger. So in a sense, this industry is incredibly dispersed, very small, not necessarily really sophisticated. The production of porn typically comes out of small little operations in the San Fernando Valley of LA, in Las Vegas, in Miami, around the world. Final point about the industry is that it has been an early adopter of technology from the beginning. So when the VCR first came out in the 80s, no surprise, the porn industry was right on top of that. That was a great way to distribute content, and they really took advantage of it. When DVDs came out, same thing. When the internet really became a kind of consumer product, and digital online streaming became possible, they were there too. So they've been very innovative about technology, less so about law. They haven't focused so much on law, they focused on creative use of technology. Now, some people in the world of lawyers have looked at this industry. We're not the first. So Kate Darling in particular wrote a really interesting paper in which she looked at how essentially the move to online distribution, digital streaming, has changed the industry. And one of the things that she found is consistent with what we found in other areas, which is that as it becomes possible to stream things digitally, or as content moves to the digital realm and becomes very easy to copy and pirate, then what you see is a kind of reaction to try to shift from product to performance. So in the online world, the rise of what are called cam girls, where essentially rather than watching a video, you actually watch a live person. Because again, using technology, they've got a camera on their computer, and you're having a kind of interaction with them online. That's like a performance that can't really be pirated and sold in the same way. So you see some of these shifts occurring as a result of piracy and as a result of the freedom to copy. So there's a kind of change in the product mix. So another way to think about this is performance beats product in a world of easy piracy. And that's one of the things that we found in many other fields as well, not unique to this. Okay, so what we're trying to do here, and in this project generally, is not so much look at that, because I think she did a good job of explaining that, but instead look at the industrial organization. So how is this industry organized? How does that relate to issues of piracy and copyright? And one thing that we found is this is not, what we see there is not unique to the adult industry. You find it in other places. And I think the main feature that we are really struck by is that online pornography, much like books today and music as well, features what we call a dominant digital distributor. So in other words, there is one company that is dominant in terms of digital distribution. For the book world, that company is. So Amazon is by far the biggest bookseller. Their share of ebooks in the United States is roughly 60 or 70%. Their share of overall books is something like 30%. They are dominant. There's no one else that comes close. For music, iTunes is the equivalent. They are the dominant distributor. So iTunes has sold over 10 billion songs at $1 to $1.29 a piece. That's a lot of money. It's probably up to 15 billion by now. That figure's a little bit old. So they too are dominant. In the online adult industry, there's a company that I'm sure you've never heard of that is equally dominant, and it's called MindGeek. And that company is enormously influential and totally dominant in this industry. And they're dominant because they own what are known, a whole portfolio of sites known as tube sites, meaning they're essentially like YouTube type sites. And by YouTube type sites, I mean these are supposedly, and sometimes in fact, user-uploaded content. So if you go on YouTube, it is user-uploaded content in theory. People are putting videos up, YouTube's just a platform. So they own a whole set of sites, YouPorn, PornTube, et cetera, all of which operate in a YouTube-like way. These are incredibly successful sites if you focus on use. So MindGeek sites collectively get over 2 billion visitors per month. If you add up all of their assets, online assets, they are the 5th largest user of bandwidth in the world. Just this company called MindGeek that, again, I'm confident very few of you have ever heard of. So they are enormously successful. And again, totally dominant. So what I want to do in the little bit of time we have, and I don't want to belabor all of this because I want to get to discussion, is just say a little bit about this idea of a dominant digital distributor and the significance of it for content creation and for thinking about IP policy. And this is the kind of, the adult industry is a kind of window on it. First of all, we think that dominant digital distributors are really significant for a couple of reasons. One is this incentive theory of IP that we've been talking about. It tells you that creators create because they want to reap rewards, and but for the protection of IP, they won't invest in creation. That's the basic logic. By that logic, the move to digital should destroy or degrade significantly content creation because it makes it very easy to pirate and copy illegally. And that is precisely what we see in the music industry. So if you look at the music industry over the last 15 years, from the point of view of the conventional industry, meaning the record labels, it's been a disaster. So Napster came along, made it very easy for people to share music digitally, and sales of CDs have plummeted accordingly. We question that, just as an aside, and we're happy to talk about that later. I think from the point of view of consumers, from the point of view of many musicians, the world is actually better than it was 15 years ago. But from the point of view of Warner Brothers, it's terrible. So that's the conventional story. Digital distribution makes the industry slowly die. So we should see that kind of negative spiral take place in a lot of other areas. If you look at bookstores, the same story. It used to be something like 4,000 bookstores in the United States. There's less than 2,000 today. And the reason can be summed up in one word: Amazon. How many of you go to bookstores anymore to buy things on Amazon? So many examples like this. And this is why the record industry and increasingly Hollywood fights online piracy and is very cautious about distribution because they fear this kind of effect. Now, there are reasons to doubt that, and many people have pointed out why there are reasons to doubt that and when I say doubt that this is a apocalyptic scenario, that in other words, the invention of the internet is not going to destroy creative work in the United States, it's just going to change it in some ways. I teach at UCLA. Mark Lemley, great IP scholar, was there last night giving our Melville Nemmer lecture on what he called faith-based IP, and attacking exactly this kind of thing. So we're not alone in this sort of thinking. But it is very important to think about not just the creation of content, but the distribution, because again, distribution is the conduit from producers to consumers. So as consumers, we really not getting. It doesn't do us any good if somebody writes a fantastic book that we never see that sits in a drawer. We have to actually access it. So distribution is hugely important. And if it turns out that digital distribution is not something that's going to degrade content production in the way that it did, let's say, for the music industry, then that's an important thing to understand. And so we want to get at that. One last point. One thing about digital distribution that's very important that I alluded to a moment ago, but I want to really make clear is it's great for consumers. So when we think about IP policy, we don't want to lose sight of that. So what I mean is, I love bookstores and record stores. We're old enough to remember going to record stores. They really have, maybe there's one in Tulsa, I don't know. There's hardly any left around. That's a little bit sad, but there's no question that going to a bookstore or going to a record store cannot compare in terms of choice, depth of choices, to what you get online today, whether it's through Amazon, through iTunes, or whatever the choice may be. There's a wealth of content available to you that was never available in your local store. So from a consumer point of view, kind of a golden age. Prices are lower, access is higher, things are better. Maybe not true for the artists, but certainly true for the consumers. Okay, so first point about digital, dominant digital distributors is that they're dominant and they distribute, but they don't just distribute. So let's just take Amazon for a second. Amazon has a self-publishing platform, fairly successful. It's also had an imprint of print books. So Amazon itself produces print books. Really hard to find those books in bookstores because bookstores don't want to sell Amazon books. They hate Amazon. So those books have a hard time getting distributed, ironically. But Amazon distributes them. But you can also, through their self-publishing platform, produce books, short pamphlets, all sorts of things. So in other words, they have leveraged their dominance as a distributor to get into the content creation business and done that with some success. Another example would be Netflix. So in TV and film streaming, Netflix is the dominant digital distributor. As many of you know, Netflix used to just first send you CDs in the mail, DVDs in the mail, then streaming, and now original content. And in some ways, that is where they are moving. So House of Cards, Orange is the New Black, these kinds of shows, films that are originally produced, these are award-winning, very popular. That's where their business model is. And by the way, Amazon's doing the same thing. So Amazon has television shows that they produce. I don't know why I'm calling them television. I don't know what to call them. But you can watch them on your computer, maybe on your TV if it's really fancy, and they're produced by Amazon. So they're leveraging their distribution network to produce content. But it's not just the network. It's the fact that they know so much about what you want. That is really the key fact. So as dominant digital distributors, they have incredible amounts of data, and they utilize that data. And in an era of big data, so kind of running alongside this whole narrative I've just told, is the ability to crunch numbers incredibly fast and incredibly sophisticatedly. And so they're leveraging that to say, what is it that people like to watch? So nobody at Netflix just said, hey, let's come up with a show set in a prison. And, there was a book, it's based on a book, but they knew what people liked, and they thought about that carefully. So let me circle back to MindGeek and online pornography. MindGeek is probably the most sophisticated user of this strategy. So 2 billion visitors a month. They have a lot of data about what people want. If you're interested, I'm not going to put this up. There's a website called pornhub.com/insights, in which they use their data to show all kinds of interesting things, like what do people search for in Germany? What do they search for in Russia, state by state? What's the most popular search in Oklahoma, etc. They'll tell you that. Oklahoma versus Kansas versus New York versus Hawaii. They have tons of data, and they are crunching those numbers. And if you go to MindGeek's website, you would have no idea what they actually do. It would look like a kind of anodyne description of they're really good at search engine optimization and blah, blah, blah. And they are. They're really good at that. But what they're very good at is utilizing technology. They are tech guys. They're based in Montreal, and they just crunch numbers. They distribute content, but they produce content. So they produce they commission and produce over 400 films, scenes a month. Now, these are not Oscar-winning films. I don't want to, that's obvious. But what they're doing is, at a very granular level, saying, people like to see this kind of backdrop. Here's what we want the actors to wear momentarily. Here's what the furniture should look like. Here's what the backdrop. We want this type of guy and this type of et cetera. So they really detail out for the producers of the films, for the content creators, exactly what they want based on their incredible mastery of data amassed from their billions and billions of users. So again, they've leveraged what is essentially a distribution network and turned it into a content network. So that's one part of how they utilize data. The other thing that's really interesting is these tube sites, much like YouTube, are supposedly user-generated content, but they're really not. In the case of YouTube, it mostly is. In the case of their equivalents, like YouPorn, they're not. There's some user-generated content, and there's lots of other stuff up there. Paid sites, paid adult sites, pay money to create a channel on these sites, and there's hundreds and hundreds and hundreds of them. And it's all, like everything on the internet, based on click-through and conversion rates and getting tiny fractions of a cent for each person who clicks on a particular thing and then maybe watches something. When you're talking about 2 billion visitors a month, you don't need a lot of that to start to aggregate real money. So they're able to leverage that. Now you might say, if you're giving away all this stuff for free, isn't that, even at the aggregate level I just talked about, isn't that kind of a losing strategy? How can you really make money at it? But remember that Hollywood does something kind of similar. So we've all seen trailers for movies, and we watch them sometimes online. A trailer is just a little teaser for the big thing, and nobody thinks that the ability to watch that trailer, that preview, destroys the desire to see the full film. The whole idea is it's like an appetizer, and you want to go out and get the full meal. So there's some of that going on as well. That's the reason the pay sites are putting things on these MindGeek sites, is they want to bring in some traffic. Now, a lot of people aren't going to go and pay, but enough do to make it worthwhile. So that's part of it. The other part is, of course, advertising. And with the kind of mass scale that they have, they make sufficient money. So you can think of it like those Nigerian email scams you get. You wonder who possibly writes back to this person offering them $1 million. But enough people do that it's worthwhile because it's so cheap to throw that out. So again, a lot of this is about scale, and this is why the dominant part of the dominant digital distributor matters. Because when you're dominant, you can make these strategies work financially. Okay, so I think the biggest point, the most important point, is the point about content creation. That we've started to see a move from just distributing to actually creating content. And so I just want to bring that back before turning it back to Chris, to some of the issues of IP and incentives that we talked about before. So if we think about the IP system, again, as an incentive-based system, you have an artist, the artist creates something because they have an expectation of reward. That sort of makes sense, it's plausible, as Chris talked about. But maybe not actually the way the world works. And if you look here in these industries, it suggests that these distributors turned content creators, they really have a very different set of incentives. So let's take iTunes for a second. Does iTunes really care about, why are they selling, why is Apple in the music business? Well, it does make some money, but Apple is an enormous company, and the music side of Apple is minuscule. That's not why they're doing it. They're doing it to sell hardware. They're doing it because if you're really into iTunes, well, then you're definitely going to stay within the Apple ecosystem. You're going to have an iPhone, you're going to have an iBook, et cetera, et cetera. You're going to make sure your iPad is linked up. It's all going to be there, and it's really easy to access and search, and they've made it simple. So it's a mode of selling hardware. So the content, so whether there's copying, I don't care. It's just to get the hardware out the door. Amazon, similarly, has an incentive to be your store for absolutely everything. So Amazon Prime is part of that. I don't know if they do it here in LA and some other cities. They're actually in the grocery delivery service now. They're doing everything. So these are all non-copyright driven strategies. They want to drive traffic. So in the case of MindGeek, what they're really doing is saying, we want to bring tons of traffic in. If stuff gets copied and spread around, that's just fine as far as we're concerned. We're distributing it, we're selling ads, we're getting pay site kind of kickbacks in essence. We don't mind if stuff is copied, and if it's illegal, we interviewed their CEO, and they told us that they deal with thousands of DMCA, Digital Millennium Copyright Act takedowns every day. So they engage in that, but that's not what they care about. What they care about is just getting eyeballs on the screen and monetizing that. So these are non-copyright driven incentives to create. So the content they're creating is not about reaping the reward of copyright. It's about something totally different. And that has interesting ramifications for copyright policy. So as we move to a world where content is increasingly online, and at this point almost every form of content that can be digitized has been digitized, that really starts to change the incentives and change the way that we ought to think about how copyright works. So the way we can think about it is that the order that's being created is not really about copyright law, it's about something else. So the interesting question is, well, what is that something else and how does it operate and what does it mean? So in each of these industries, the answer is a little bit different. In adults, I can't say we know enough to give you a final answer, but certainly there's a lot of suggestive answers. So with that in mind, let me turn it over to Chris to kind of wrap things up.
I'm going to finish up very quickly, but let me just say that the story is very detailed. The story is very rich in each of these industries. And the story leads to a whole bunch of other ideas about what we think about this. So the dominant digital distributor has some alternative strategies for incentivizing production to show us, and that's extremely interesting. They are also potentially monopolists, right? So we have to worry about their effect on competition downstream. We have to worry about whether, in fact, Amazon has power over price in the future in some product category like books. So this is not a totally happy story. Like most complicated stories, it has both a happy and a somewhat frightening face. I want to just add something a little bit about Amazon. So, think about the dominant digital distributor strategy again with Amazon. Why are they so eager to sell you a Kindle? Not because they make a lot of money selling you books. They don't make a lot of money selling you books, and they don't even really make a lot of money selling you the hardware, unlike Apple, which makes a ton of money selling hardware. The focus of Amazon's Kindle strategy, which is the focus of their strategy really, is to get you to buy a Kindle because they know that once you have a Kindle, you will be on their platform, right? Just like Apple has a platform and they sell you music at a pretty low price just to keep you on that platform, Amazon wants to capture you on the platform because they know that that platform makes it easier for you to shop at Amazon and more likely for you to shop for everything at the everything store, right? So this is their strategy. They are incentivized to create in order to pursue this strategy. And they're doing it in a way that creates opportunities for authorship that didn't exist before, which I think are interesting. So, I talked about in comedy how the difference in IP strategies changes not how much is produced, but what's produced. Amazon's beginning to do that too. So there's a thing called the Amazon single. Now, this is basically the resurgence of a market in pamphlets, which we had in early American history. The pamphlet was an incredibly important part of American literary output in the 17th and 18th centuries, to some degree in the 19th century as well. And it died away, and it's coming back. So if you have something to say in 5,000 or 10,000 words, you can say it, you can write your pamphlet. Amazon has a whole bunch of publishing tools, and you can publish it in the Amazon market and keep a big chunk of the money. So this market is coming back, and it broadens the scope of literary creativity. So I wanted to wrap this up with a kind of more meta observation about what this means, and what this means for people who study IP, what this means for people who work in the field of IP. All of this work taken together, I think, raises a very basic question, which is what exactly is our field, right? What is it that we care about? I think what these case studies show is that the field, as I said before, is innovation, that IP is a tool, but it's only one of the tools that we can use to help bring about innovation. The legal centralism story that we've been talking about all this time isn't sensible in the IP field. There's legal centralism in some pieces of IP, maybe more in pharmaceuticals, maybe more in blockbuster movies, but less legal order in others, and some very important ones. The fashion industry is $200 billion a year in commerce in the States, probably about 1.5 to 2 trillion around the world per year. It dwarfs the record industry. It dwarfs the movie industry. It's huge, right? The cuisine industry, which operates, as Chris Buckafusco told us yesterday, again on a set of norms and a relatively low IP structure, is an even bigger industry. So how do we move away from the ideology of intellectual property being at the center of this field? How do we deal with a culture of IP academics and IP lawyers that imagine that there's an IP solution for every innovation problem? I would close by saying this is not just a rhetorical or an ideological question. It has real-world consequences. We need innovation, right? It is the thing that human beings do that over time tends to make life better, longer, less brutish, nasty, and short. We should care about fostering the conditions that lead to it. And the persistence of legal centralism in this field is likely to lead us astray in that search. So to some extent, this scholarship is a call for the shedding of ideology and the shedding of legal centralism and the opening of our eyes and looking very carefully at creative communities, getting down and a little bit dirty and trying to figure out how they work. We thank you for your attention, and we appreciate the invitation to talk. Thanks.
We want to have some questions, and I want to ask the first one. So I'll start it out, and then everyone can follow. Question I had, I've always been very interested in your work that you've done and are continuing to talk about with stand-up comics.
Yeah.
And I think it's interesting. You mentioned that there were on stage joking and ridicule of thieves.
Yeah.
The thieves of the thief of bad gags. Milton Berle, Bob Hope was often made a butt of this. So was Jack Benny and so forth to some extent. And I wondered if I've actually got two questions. I'll say them kind of quickly. I wonder if that is some evidence of a transitional period to the period that you're talking about. It's clear that this content is free at the time, but there's almost a sense of aspirational statements made in a jocular vein that evidences a discomfort with this that maybe now we see fully realized in the norms that you're talking about. That was the first thing I'm wondering about. Well, I'll leave it at that.
Yeah, so I think in the vaudeville period, you do see joking around about this. It suggests to me that it was never as if comedians celebrated the corn exchange. They realized that it was the fact, and this is how things ran. So Phyllis Diller's joke file is a great example of this. So in Phyllis Diller's joke file are hundreds of index cards that have panels from a comic strip called The Lockhorns. Do any of you remember this? It was about this married couple who were really, truly terrible to one another, right? So she cut these out of the paper and she pasted them on index cards. And if you are familiar with Phyllis Diller, you can see the Lockhorns panels reemerging in the jokes that she tells about her relationship with her fictional husband, Fang. Okay, so she appropriated, and this was extremely common at the time. So it's not as if this is something that no one ever feels an element of shame about, but it is a regular element of the practice. Now, if you talk to comedians now, the antipathy for joke thieves is so deeply held and so vicious. And the guys who write South Park, I think, are a pretty extreme example of this, but they beat Carlos Mencia to death because he claims to have written a joke which he stole. Okay, and the level of hostility is just off the charts. Now, what do I think about this? I mean, Ronald and I, who wrote the original paper that Cal and I adapted for the one chapter in the book, Dotan and I, note that this is order without law, but it's not necessarily an order that is untroubling. There are some troubling things about this order. So, wouldn't it be nice if comedians actually were conscious of comedy history a little bit more and presented it to us? Wouldn't it be nice if, some reworking occurred to kind of update old comedic bits for, a new audience? So think of Abbott and Costello. So when I was a kid, I loved them to death. That Who's On First bit that they did it's a part, of my growing up. I loved it. No one will mind that bit. No one will perform that bit. That bit is dead. Right? So a new generation of kids who don't grow up with Abbott and Costello movies, they'll never know that. This is a problem in the culture of comedy. This norm system exists. It's not as if it provides a perfect system, but it provides order. And it is, in fact, the practice, the way they act.
Bob, should we call on people? Or
Yeah, go ahead. Yeah, sure.
You want to do one?
I get nominated for this? Yeah. All right.
I'm wondering if I could introduce two ideas or concepts and see whether they work for your materials. I'm struck by your beautiful attempt to describe the workings of specific microcultures. But one of the things that fashion has in common with certain other kinds of microcultures is it's very linked to temporality. So I wonder whether the temporality of culture is an analytic that can help explain some of the modes of protection or non-protection of IP. This goes in the 19th century when it was hard to sell books. and magazines. The middle brow magazines included fashion plates because people needed to keep up with fashion, right? That fashion has a clear temporality. You don't want to be, you mark your provinciality by how, whether you're wearing last year's clothes or this year's, right? Which is to say that the temporality of certain forms of culture are a motor for circulation. And it might be able to link them. And another characteristic of certain kinds of mass culture is not originality so much as novelty. And Poe interestingly theorizes the difference between the two. The hunger for something slightly different, not absolutely original, which might appertain to a higher cultural status, but something just new enough to keep you clicking.
Yeah, I think those are two really good questions. On the first one, I would say the issue of what's cause and what's effect is hard to know.
Right.
Now, Shakespeare said the fashion wears out more clothes than the man. So it's not a new idea that fashion comes and goes, and styles come in and out. He talked about it, and I think he didn't need to explain to his audience in the 16th century. So obviously this isn't. That said, it's definitely a little faster today. Yeah. And so there's that. But I think what's cause and what's effect is kind of interesting. I'm not exactly sure. I think there's an endogeneity to this that's going on. So the fact that there is freedom to copy is certainly accelerating that process. But would it eliminate it? No, because you could just look to Europe, for example, where the European legal regime is totally different, and nonetheless, cycles happen. So there's that part. The novelty is interesting. We've kind of talked about this before. Many people say, well, look at fashion as such a kind of frivolous thing, and which I kind of debate. I don't know, is it really more frivolous than like art or music or anything else? That's a kind of eye in the eye of a older issue. But there's no question there's a lot of variations on the theme. That said, you could say the same about a lot of other art forms. So movies, but any popular art form.
Mass culture, yeah.
Yeah, any mass culture is going to have lots of novelty and maybe not.
But high culture too. This high-low thing I think is. So let me back up for a second on the first part about temporality. Just to make clear what the mechanism is. So we think temporality has a lot to do with the mechanism in fashion. But I want to stress that all these stories are different, right? So they have some things in common, but they're not the same. So with fashion, so a design comes out, it proves popular, right? It's widely copied. The copying sends a signal to people that this is going to be a trend. People jump onto the trend. Why? Because they want to be in fashion. They want to be in the mode. That's the point, right? They want to flock together with other fashion.
Some people do.
Some people
but
do.
Enough to move.
But they jump into so then copying keeps going. So the trend gets widely copied, and at some point, the people who don't want to look like everybody else think, well, this copying has gone too far. I'm jumping off. Like everybody's wearing Uggs. I'm jumping off, right? So what do they jump off into? The new trend that copying is starting to cement. So copying helps create the trend, copying helps keep the trend, kill the trend. The cycles in part because copying pushes it, right? So this is the basic mechanism. So temporality has a lot to do with the fact that fashion functions well without design protection. The trend-making process means that you get very quick cycles of innovation. In one cycle, company A might be a winner. In one cycle, company B might be a loser. But there's enough cycles of innovation where over time and across the industry, you can sustain incentives to innovate. Okay, so that's the temporality point. This point about high-low culture, I've thought about this a lot. People, there's some psychological studies on what kind of innovation people want, and it's far from clear that people want like groundbreaking innovation in art. They might want groundbreaking innovation in pills, right? But in art, what they tend to want is they tend to want things that fit within frameworks that they understand, right? So the first impressionist painting looks crazy, right? The 100th impressionist painting looks great. It's a very complicated question about how much differentiation IP law should be provoking if what we care about isn't creativity as a thing in itself, but creativity is a thing that satisfies human desires.
Yeah. Someone said something like art is something that's, I know I'm going to put it.
Thorstein Veblen.
Yeah, the line about it's art of things that are ugly at first and become beautiful over time.
Yeah.
And fashion is the opposite.
I think Sean Clark first.
Yeah, there's something to that.
Chris, and then tomorrow.
So you guys tell this really interesting story about the relationship between distribution channels, norms channels, and copyright channels, and the kinds of content that get produced. Right? This is the comedy story. It's many of these stories, and as Chris, you were saying, there are challenging welfare effects of things, right? It's very difficult to specify the welfare effects of whether it's better to have more Henny Youngman or more Sarah Silverstein, right? So let me suggest, and you tell me if I'm wrong, I'm going to give this to you guys as a possible argument, that one of the reasons for studying adult entertainment is that at least there the welfare effects are easier, right? That, you know, if what we're getting with respect to the porn tube sites and it's much more individualized content for consumers who have heterogeneous preferences, and each one of them is able to satisfy his or her preferences at a much higher degree of specificity, then he or she is better off, at least from the consumer surplus perspective, all things equal, right? We don't have to worry about this, do you prefer, jokes that you could share with your family versus jokes that have important social commentary, right? The benefit of porn is that it's just porn, right? And that to the extent that it satisfies people's preferences, all the better.
It's never just porn.
Oh well, so that's what, right? So the question. Right, so is this easier quantitatively? Is it easier qualitatively, or is it like it's equally impossible with respect to specifying the welfare effects of changes in the distribution?
Interesting. I don't know. Well, so I think the consumer benefit story is very strong in online adult entertainment, and this has to do with the proliferation of niches, right? So there's incredible product differentiation that's driven by this data acquisition, right? So the consumer benefit story is relatively easy to tell, but there's another story. So what we care about obviously is total social welfare, and that means the joint product of both consumers and producers. So consumer benefit, producer benefit. When you add them together, what do you get? So what you get in the porn industry, by some accounts, is the driving down of wages, the cheapening of content. Some of this is because the technology makes the content cheaper to produce and distribute. Some of this is because it's really hard. There's no such thing anymore as a porn star, right? So porn has become democratized, but the kind of rents have been driven out of it. Now imagine what would happen in Hollywood if that's the case. Like Tom Cruise wouldn't get $10 million a movie, right? There wouldn't be super agents that drive around in Lamborghinis, right? Hollywood is a story of rents being enjoyed by producers. The online adult entertainment industry has some of that, but a fraction, right? What the story is in online adult entertainment is technology driving benefits, if you want to call it that, for consumers, at least consumer demand being satisfied. What the total social product is hard, in part because there's a whole argument that we don't even attempt to address, this kind of overlaying argument about whether is this a preference just like any other preference, that is the preference to consume pornography, or is this a preference that has some bad effect? If we were talking about the efficiency of the market for distributing cocaine, I think we would worry, right? And what your perspective on like the moral outcome of this market, I mean, it's not the point we're trying to make, because we don't really, that's not the interesting part to us, but to do what you're suggesting we should do, someone's going to have to do that work.
Yeah, I would just add, you could say this, people said the same thing about fashion too, even though it's not, that's more related, obviously. But, similar kinds of things, like, is it bad to have this disposable world of fashion? Which, by the way, it's not just an IP issue, it's also about the fact that you can now very cheaply produce things in like Bangladesh and bring them over here, and so clothes are in real terms, clothes are the cheapest they've ever been by far, and so our grandparents paid, multiples of what we pay for clothing today. And, there are kids who go and they just buy, not just kids, they go, again, places like Forever 21, they buy stuff, they wear it twice, they throw it away, no big deal, it costs $10. It's incredibly cheap.
Environmental, labor issues.
Environmental problems, labor problems, so there's a lot of morality running through it, which we're not addressing, and obviously super true in adult entertainment. The other last quick reaction is, I think there is, you see this in music too, the same technology that enables digital distribution enables very easy production, and so there is this kind of leveling effect. So musicians today can be, back in the 70s, you had to pay for this really expensive studio somewhere in, West Hollywood, and all this money, and you had to have a record deal, and it was lots of barriers to entry. And then maybe you made money, but really probably your agents and your label made money. Today, you could be someone in your room with that computer and maybe a slightly better microphone, and you could produce it, and then you put it up on YouTube or MySpace, and suddenly you can be a star, or at least you could sell something. And so it levels everything down, and nobody sells units the way they did 10 or 20 years ago.
Taylor Swift.
Even, yeah,
Yeah,
so
that's
everyone's
about
so excited that Taylor Swift sold a bunch of, but it's nothing compared to what happened in the 70s and 80s in terms of numbers, sheer numbers. So the industry has totally kind of leveled out, but also spread out. And I would say that's probably pretty good from a kind of point of view. More people are producing more music and hearing more music, and maybe they're not getting super rich and having their own private plane, but, you know, is that really a good thing? So, and Hollywood hasn't gotten there yet. So I think a lot of these things are about leveling, and that's probably positive. But again, that's not really our expertise.
Tamara? And then
Yeah, I'm thinking from especially the last part that this is a law reform project to some extent, right? That you are urging to try to push back on the legal centralism a narrative, but so you're not just looking at this from the standpoint of social scientists or historians or something, but then the question is like, who's the we there in the we? Mm-hmm. And you know, that total social welfare question with respect to law reform and like whether, because I mean I see the immediate application in something like fashion, which some people have been pushing for IP protection, right? As some pushback to say, no, let's not rush in there to give it to them because it might be working fine without it. But if it's working fine without it, that also gives rise to the possibility that some domains that have IP protection now don't really need it, and that there's a general social net loss in social welfare because of IP protection, that maybe we should reconsider the coverage of it. But you can't do that, it seems to me, without thinking about those other things that we were just talking about, you know, social welfare is measured in some other like what kind of entertainment industry do we want, which brings me back to the question of who's the we, right? Like, and it seems like in the we that are the people that are producing the laws, there's a heavy skewing towards the producers and to these property sort of conceptions of what constitutes social welfare that is also reproduced or you find some roadblocks or some speed bumps or something in things like, you know, the Fifth Amendment and, you know, takings and whatnot that would make it difficult to experiment. So you couldn't just like remove property protection and then say, oh no, actually, you know, it didn't work out so well, so we're going to put it back. Huh?
You can remove it prospectively. I mean,
you could, right.
But we're not even, I don't think we're even talking about that. I mean, so our agenda would be much more modest. So there were a bunch of people who said, let's extend copyright to fashion. We testified a couple of times saying maybe that's not a great idea. So that's one way we can intervene. Another way we can intervene is something like the following. So it's now a couple of years ago that Congress proposed two laws, the Stop Online Piracy Act and the Protect Intellectual Property Act, that would have forced search engines like Google to delist sites that were deemed to be, you know, rogue websites. Now, there were very loose definitions of what a rogue website was.
Maybe IP infringing.
IP infringing. And that, in the House bill, that actually didn't even have to be done by the government. That could be done by a private party, right? So, I mean, you know, I think people who question whether that is really necessary could look at our work and say, well, like the music industry, does the music industry really need to have like a break Google law to actually do what they need to do to make money? Probably not. What the music industry probably has to do is reorganize, right, in ways that are already starting to happen, but they probably have to do it more assiduously. So I think, you know, law reform is always a super tricky thing, and you're right that the political economy of law reform is very producer-oriented at the moment, but, you know, that's not guaranteed to last forever. I mean, our project has not been focused on law reform in itself, but it's been focused on building the infrastructure for understanding whether the current laws are good, bad, and different, like whether they make sense ideologically, whether they make sense on their own rhetoric, and that's more what we're...
Well, I guess though but to the extent that you were saying that there's some of these, all these domains seem to be a little bit sui generis, right? So that you just said that there's, you know, that what works in comedy may not be true, the adult industry, and et cetera. But we don't know, in some sense, what's going to be driving it until the sort of like you don't know what the rules are going to be like after you remove the rules, or whether or not something will spontaneously.
This is a version of legal centralism
Yeah.
now. Removing the rules doesn't mean repealing the law. It means Napster. Napster removed the rules. Grokster
Right.
continued to remove the rules. Right? So technology removes rules. So if, we're going to get lots of natural experiments. Technology is going to come along that's going to remove rules in a whole bunch of industries. And, we're not going to react right away. There's going to be a period where we decide what to do. And in deciding what to do, we can point out the way that industry or other industries are functioning when rules are removed. So I think that's where we can be salient.
Yeah, I mean, you're absolutely right. I think every industry, in a sense, is unique. And one of the big kind of meta points that we made in our book, and I think continue to try to make, is that every industry is different, and our IP system is kind of a one-size-fits-all system. So the patent's 20 years, copyright term, they're just fixed, and it doesn't matter whether you're talking about film or what.
Shampoo bottle labels.
It's all the same. Yeah. And so that's sort of problematic. So maybe that's, now again, I completely agree with Chris, it's a big step to go and say, well, hey, we're going to start fiddling with the IP system and expect that to actually happen. That's not really going to happen. But I think what we can do is begin to make people think that, well, maybe more IP isn't always better, and maybe each industry is a little bit different. We don't have to be so concerned in certain areas. And I find that, particularly in the practicing bar, so I've given a few talks at the LA Copyright Society, and the people who are there are members of the practicing bar, mostly Hollywood, music industry people. They are IP maximalists to the max, and they have a very hard time with this. But they will sort of say, like, that's kind of interesting. I mean, they'll at least open up a little bit. They don't come away convinced, but I think just doing that is sort of valuable to get people to think, maybe it isn't always a more is better story. Maybe there is another side. And when they hear about these other industries, it does, a light bulb, I think, seems to go off. Maybe I'm just optimistic. But in any event, I don't think we can do much more than that.
I find some ambiguity in your ultimate normative position. This is more based on your book than your remarks this morning. And so let me address this to Cal, because I'll use fashion design as the example. To me, the thought that the current regime is better than copywriting of fashion design is kind of a no-brainer, and you can win that one. But that does not imply necessarily that we are in the optimal world of complete knockoffs. And so imagine a world where Forever 21 has to wait for 30 days or something like that. If you want to do what Chris wants to do, which is maximize creativity, it's possible you get more creativity with some more subtle kind of IP innovation protection. So so you nodded as if the status quo is not necessarily optimal for you, but that leaves open the question about what modest reforms might make.
Yeah, no, I agree 100%, and I don't think Chris differs. I mean, we have been on record, and as Chris mentioned, testifying and writing op-eds, and been part of the debate about changing legislation in Congress over fashion design. That said, I don't think we know what the world would be like. We know something because we can look at Europe, we can look at Japan, we can look at other big markets, and so we can see. What's striking in some ways is the law is really different and the practice is not that different. Now, it's true that there's no Forever 21 in Europe, but there is Zara, H&M. These are European companies, and they're really big in Europe. So to me, the most striking thing is you change the legal framework in these two very large markets, and the practice is almost identical. So I would tend to think that suggests that minor reforms would do almost nothing. So now you can flip that around and say, well, then maybe that minor reform is no big deal. And so the last version of the bill that was proposed was better than the earlier versions, in part because it was much more narrowly defined. So at the end of the day, I don't think it's a good idea, but I could kind of live with it.
Yeah, I'm
but it's not a good idea.
I'm much more cautious. So I practiced as a lawyer for a long time, and lawyers are troublemakers. And we have a very different legal culture here than they do in Europe. We have much more powerful civil litigation, much more powerful discovery rules, much higher remedies, damages. I think that if you get the camel's nose in under the tent at all, you will have in this gigantic and actually pretty cutthroat industry, you will have just a fusillade of cease and desist letters, and what that will shake out to be is that well-capitalized, relatively large fashion companies will hire lawyers, will have an enormous competitive advantage over their small upstart rivals. So the young woman who wants to go to Brooklyn and open a boutique is going to be much worse off in that environment than she is now. And which is ironic because the people still are selling it as the bill that protects the young woman opening a boutique in Brooklyn, which I think is precisely the opposite. The minute you bring lawyers into the equation, you privilege the weak you privilege the strong at the expense of the weak, which is really what I think lawyers do in society. They defend the strong for most parts. And, you know, there's a few lawyers
who
who
don't
don't.
that far.
Well,
he's generally, I agree 100% with everything about that. I know there are a lot of lawyers in the room. Let me just add one other thing. We see this already. A lot of it is just about the cease and desist letter. So just to give an example, we're currently working with a small apparel company, very small, that's being pressured by a very large Canadian company that's 1,000 times the size, literally, of this company. And in all these instances, it's about the use of the cease and desist letter, which is very effective in an industry that, like the adult industry, is pretty tiny. There's a lot of little entities, and they don't have legal counsel. They don't know what to do. So, so it's true that when you get lawyers involved, there are a lot of costs. But I don't think lawyers are just as bad as we're in a law school. We gotta stand up a little bit. Not really. Got it.
So I wanted to push you a little bit on you anticipate in this regime wages for artists, I think you said at one point, might decline. We could see that in music. But nevertheless, we might see a lot of innovation. And I'm wondering what your theory is about declining wages for creators and human capital development. The anecdotal evidence, the kind of Google, YouTube television model, the non-Hollywood model is everybody sort of does it themselves in the green screen in Playa Vista, and all of that's amazing, assuming that they develop human capital basically at their parents' expense by going to film school at USC or UCLA, right? And work for free, which is, you know, their human capital development is funded by presumably family wealth combined with, you know, being a starving artist in the garret. And so I'm wondering if you have a theory across industries of different levels of need for human capital development and where the money for that is going to come from if you no longer have sort of slack generated by kind of monopoly profits or something like that.
It's a great, I don't have an answer to it, but I'll just say I'm not sure that there are declining wages. I think the wages are spread out. Or I think it's equally plausible that we don't really know. But I think, again, just to take music, I think it's much more plausible to me that what we see are lots of people making kind of a middle-class living as musicians. So maybe they sell a few units, whatever it is. They can go on tour now. They've got a YouTube presence, a MySpace presence. They're not going to strike it rich, but they can live their dream, whereas in the past they got crushed because if they didn't get in the door of Warner Brothers, never got off the ground. So I think you've just seen a flattening.
Yeah.
But again,
we have some data on this actually. So the Bureau of Labor Statistics does a survey of job categories and wages within those categories, and you do not see significant declines in the wages within the job categories that you're talking about, and you don't see significant changes in the labor participation in those job categories. You don't see people seemingly deterred from entering into those job categories. What you do see, I think, is first of all, you see intermediaries making less money, which is interesting, but not necessarily fatal in a technological environment where intermediaries are just not as important. So to be perfectly blunt, record labels are not as important as they were in the recent past. They're just not. And you see some effect where it's actually a mixed effect. So some superstars are less superstar-y than they used to be. Right at the very top, there's some cutoff. But there are other opportunities for superstardom, just different opportunities for superstardom. So I think the system that we have now selects for different superstars, which is kind of interesting. But the wage effects are ambiguous. Now you hear a lot of complaining from artists about compensation. That is a forever thing, right? And what that forever thing attaches to whatever the current anxiety is, and the current anxiety is Spotify. Yeah.
Yeah, no, I think they just hate. You know, but again, it's a bias issue. It's like you talk to the one. By definition, if they're able to complain, they've made some level of success. They probably wouldn't have been there at all. We saw the same thing in fashion. people will complain, they'll trot out a story of, oh, you know, I designed this great dress, it got knocked off, I'm really irritated, really frustrated, look at all the sales I lost. And in a sense, they're right. It's like, well, it's selling now in this, you know, the Forever 21 version. Yes, but as Chris pointed out a moment ago, if you aggregate that across all of these things, you start to see a kind of spreading out of the wealth. So it's the difference between a kind of collective assessment and the individual.
You don't hear from the person who jumped onto the trend and made a nice return this season on the thing that she adapted from some other designer. You don't hear from the Spotify artists who would never have been distributed by a major record label because Spotify can distribute the long tail and the major record labels can't, but then now they're getting something on Spotify. So, you know, it changes the income distribution. I'm not sure that it changes the total product very much. If anything, it makes it go up. But again, it's like the people with the power to complain, with the access to the megaphone, are the ones complaining.
Yeah. Not totally responsive to your question, but that's the best we can do. Maybe we should take one more, if there is one more, or call it a day. All right, good. Thank you,
Thanks.
everyone.